Can a non-sectarian policy for tuition assistance payments violate the First and 14th Amendment? Carson versus Makin, 2022. In a 6-3 decision, the Supreme Court ruled that Montana banning government tuition assistance for private schools who are religious affiliated does violate the First and 14th Amendment. So all private schools can receive government tuition assistance. Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett all agree. The situation is this: Maine has a non-sectarian requirement for any school who wants to be a recipient of families who have tuition assistance payments. According to Roberts, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, Maine cannot survive strict scrutiny because the policy allows for a stricter separation of church and state than what the U.S. Constitution allows. First, the requirements between a public and private school are different, so religion should not be the only requirement to receive funding. Locke versus Davey was decided about discrimination because the funds were used to help students become ministers, when in this case, it is about educating students. To be a private school in Maine, a school needs the following: currently accredited by a New England Association of Schools and Colleges, must meet curriculum requirements to maintain student-teacher ratio of 30:1. There is no geographic limitation. Single-sex schools are eligible, but in 1981, the sectarian requirement was added. There are two families, one who attended Bangor Christian School and the other Temple Academy. Both schools are accredited by the New England Association of Schools and Colleges, NEASC, and the department that counts attendance for compulsory purposes. Their tuition assistance programs was denied. If a school follows everything, but is affiliated with the church, then it is unfairly being discriminated against by not receiving state funds. It is religious discrimination if religion is the sole factor for denial. There are three dissenters, justices who do not agree: Breyer, Kagan, and Sotomayor. Breyer and Kagan stated that the First Amendment forbids the government from making any law respecting an establishment of religion. Maine's non-sectarian policy aligns with the First Amendment. The Constitution bars the government from sponsoring religion through government grants going to private religious schools. A separation of state and religion is a necessity. Public funds should not be used to aid any religious sects to disseminate its doctrines and ideals. Both Bangor Christian and Temple Academy have biblically integrated education, which is different from the public school that offers a civic education with democratic principles. Maine's non-sectarian requirement was served to avoid the religious strife between state and religious schools and the public. We are a nation of 330 million people with 100 different religions. Sotomayor also disagreed with saying that she does agree with Breyer's dissent, but she wants to add that the courts have started down this path 5 years ago, in 2017, with Trinity Lutheran Church, Inc. versus Comer. States can fund religious indoctrination with taxpayer dollars. The decision was not rooted in the U.S. Constitution. The court leads us to where the government and church separation is a constitutional violation.